Okay, time being 6:30, I'd like to call the special meeting to order. Council of the Township of Red Rock hereby acknowledges that we are on the traditional territory of the Robinson Superior Treaty and that the land we gather on is home to the Red Rock Indian Band, the Anishinaabe, and Métis people. Are there any amendments to the agenda? Seeing none, can I have a mover and seconder to approve the agenda as accepted, as presented? Councillor Brand, Councillor Muir, all in favor? Motion's carried. I'd just like to remind those that are here tonight, if you have your phones, please put them on silent. Okay, make sure the ringers are off. This is not a public meeting, so you cannot speak to it. So if you need to leave, then you can get up and leave, but please try not to speak during the proceeding or during the meeting. Okay, any declarations of interest? Councillor Brand?
I have a declaration because of the possibility of a pecuniary interest in the suspension of enumeration.
Okay, I am also declaring a declaration of interest. We will, once we get to the discussion, reprimand portion of the meeting, I will not be voting when it comes to Councillor Brand or myself. I will participate in the discussion portion, and I will pass the chair over to Deputy Mayor Muir at that time during the discussion session. Okay, so as the evening is going to go, we're going to have John Pappas, right? Okay, he's here to review the role of council. This is an education session. That is the time if council wants to ask questions. So that is your question period to ask him whatever you need, okay, for any guidance. After that, we're going to follow with E4M, Services, Code of Conduct, Mr. Sean Sparling. That will be a report only. We will receive that report, no discussion. After that, then we go to deliberations, okay? Okay, so we have our first presentation. We have John. John, can you hear us?
Yes. Good evening, Madam Mayor and members of council. Can you hear me all right?
Yes, we can.
Thanks very much. So I'm gonna pull up a slide deck on my own end, and then we'll proceed. So you can let me know when that's visible to members of council.
Yeah, we can see it.
Great. Many thanks, Madam Mayor. So I don't anticipate being very long. This is a brief presentation, but I think a pointed one. My understanding is that council has not yet considered a code of conduct report in this term of council, and it hasn't had occasion to perform this role or this exercise at this point in time. By way of background, I'm a partner with Airden Burles in Toronto, and I practice exclusively in the area of municipal law, and that includes a considerable amount of work within the municipal accountability regime. Our firm acts as integrity commissioner for a number of municipalities in Ontario, and we also advise municipalities on this regime generally. In my presentation this evening, which will cover a few basic topics, and sorry, I'm just trying to control my screen. I'll start with a very brief background, but the heart of it really is the roles and responsibilities within the municipal accountability regime. And so that's the regime set out both in the Municipal Act and within your Code of Conduct. I'll be speaking about the Integrity Commissioner's role, council's role as a whole, as a body, and the obligations of individual members of council. After that, I'll explain the statutory penalties that are set out in the Municipal Act, as well as the topic of remedial measures. So as members of council will be aware, at present, all municipalities in Ontario must have a code of conduct in place dealing with the conduct of its members or of their members. This comes from the Municipal Act, and this comes from Bill 68, which was adopted in 2018, and it changed the landscape of this regime. A number of municipalities, including the township itself, had codes of conduct prior to this. The township itself adopted its code of conduct at first instance in July 2017, and that was based on a recommendation from a report from the Ontario Ombudsman. Part of this framework, part of the township's ethics regime, is also the bylaw setting out the Integrity Commissioner protocol, which sets out the process by which the Integrity Commissioner reviews and investigates complaints and reports to council. The role of the Integrity Commissioner is largely set out in the Municipal Act, and those functions have all been assigned to E4M as it relates to the township. The Integrity Commissioner is an independent statutory officer, an accountability officer, if you will, that reports directly to council and exercises their functions independently of the municipality. The functions that are given to the Integrity Commissioner under the Act relate both to the code of conduct and also the Municipal Conflict of Interest Act, which deals with financial interests that a member may have in matters arising before council. Part of the role is advisory or educational in nature. The Integrity Commissioner has an advisory mandate for members of council to prevent violations of the ethics regimes and also providing general education to members of council. The larger part or the larger bulk of the mandate is investigating complaints and conducting inquiries about the conduct of members, and in so doing, making recommendations to council about the penalties or corrective action to be imposed for breaches of the code of conduct. As it relates to investigations, the Integrity Commissioner exercises powers under the Municipal Act dealing with findings of breaches of the Code of Conduct. These investigations are undertaken, again, independently of the municipality and in private, and the Integrity Commissioner protocol sets out how that process works. After an investigation is concluded, assuming that the complaint isn't dismissed or disposed of without a full investigation, the Integrity Commissioner will issue a report to council, and that will do two things. First, it'll make findings as to whether or not the conduct of a member has breached the code of conduct. And secondly, the report will make recommendations as to the penalties council should impose and or any remedial action that council or remedial measures that council should impose or implement to deal with the conduct at issue. The latter two are recommendations only. And in recent years, the case law from our courts in Ontario have described and fleshed out what role falls to the Integrity Commissioner and what role falls to council. When council receives a report from the Integrity Commissioner, its role is to review and consider that report and decide what the appropriate penalty is in the circumstances and whether there are any remedial measures that should be imposed. I'll be very clear about what council's role is not. Council's role is not to revisit the findings that have been made by the Integrity Commissioner. Council's role is not to make its own assessment or its own determination about whether there's been a breach of the code. Those are factual findings that the courts have been very clear on are made by the Integrity Commissioner alone. And a recent case out of our divisional court from March of this year, Rocco in the city of Vaughan, this was a legal challenge to an Integrity Commissioner's report and City Council's dealing with that report. And the court says very clearly the role of council is not to make factual determinations or reach conclusions about conduct. It is only the IC's report that reaches those types of determinations. And this builds on case law that has come out from about 2020, 2021 onward. In another case called Jonkers in West Lincoln, this was again a legal challenge to an Integrity Commissioner's report and how the municipality dealt with that report. The court said in dealing with an argument that council should have dealt with the penalties in a certain way, the court said it is the Integrity Commissioner who's given the power to determine whether a member has violated the code of conduct. Council is bound by the Integrity Commissioner's findings with respect to whether or not there is misconduct. If the IC has made no finding of misconduct, council has no further role. On the other hand, if the Integrity Commissioner does make a finding of misconduct, council may make a decision as to which penalty to impose. In doing so, council can consider the recommendations of the Integrity Commissioner, but it has to make its own decision. So it may accept, reject, or modify the recommendations from the Integrity Commissioner. And another important point, despite what the findings say, again, council is bound by those findings. What the court has said is in exercising that role and exercising its jurisdiction as to penalty, council cannot do this in a way that seeks to set aside the Integrity Commissioner's findings on the questions of whether misconduct has occurred. So by way of summary, and this is highlighting a case from the city of Ottawa, Chiarelli and Ottawa, the investigation and determination of whether there's been a breach of the code, that falls to the Integrity Commissioner, acting in its investigative capacity. Making a decision on which or whether to impose penalties or any remedial measures where there is a contravention falls to council, acting in its adjudicative capacity. Council's duty, as the divisional court said in that case, is to consider and respond to the report. Council's role is not to make determinations about whether there has been a breach. As it relates to individual members of council, so for the members that are assembled tonight, all members of council must do three things at minimum. The first is listen to presentation of the findings and recommendations from the Integrity Commissioner. The second is to listen attentively to any submissions from the member whose conduct has been found to breach the code about what the recommendations in the report are and what council ought to do with those recommendations. And lastly, all members of council must approach this matter with an open mind. And in the language of the case law, an open mind which is capable of being persuaded. A note for those members who are named in the report, and I've certainly heard this at the start of council meeting, the Municipal Conflict of Interest Act, which deals with financial interests of members of council, does provide a limited exception in this instance. Members, despite their general obligation to declare their pecuniary interest and to refrain from discussing and voting on matters, that's the general obligation, but this is altered where there's a report recommending that the remuneration of a member be suspended. Despite those obligations, the member can take part in the discussion. They may make submissions to council, but in any event, they are not permitted to vote on any question in respect of that matter. So given the Integrity Commissioner has found breaches of the Code of Conduct, it's in order for council to impose one of two penalties. And these are different from remedial measures, which I'll come to in a moment. Under the Municipal Act, there are only two possible penalties or sanctions, as I've heard them be referred to. The first is a reprimand, and the second is a suspension of pay for the member of up to 90 days. These are the only two sanctions that are permitted by the statute. Over the course of a few decades, the courts have clarified that although there are only two penalties, keyword penalties, set out in the Act, council does have limited authority to impose what are called, or what have been described as, remedial measures. In a case called Magder and Ford, that dealt with former Mayor Ford of the City of Toronto, where council had passed a resolution requiring him to reimburse certain funds that were spent or misappropriated in contravention of the code. The divisional court in this case said that a generous reading of the city's powers to pass a code of conduct under the City of Toronto Act, that's like the Municipal Act, would support the validity of including remedial measures in such a code. In subsequent cases, including a case called Villeneuve and North Stormont, the divisional court again clarified that a municipal council may require remedial actions in addition to penalties to respond to the conduct underlying the complaint and to provide redress to the complainant. And this has been reflected in several cases that have been decided in recent years, including narrowing the contours or defining the contours of what a remedial measure is. Any other measures that are imposed by council must actually be both in purpose and intent and in operation corrective or remedial. There must be some remedial nexus or some connection with the issue underlying the breach of the code of conduct that's been found. So for example, where there's an issue of misappropriating funds or inappropriately accepting gifts in contravention of the code, there would be no connection if council's supposed remedial action is to prevent the member from obtaining confidential information in the future. There's no connection whatsoever, rationally or purposively, to the harm that's been done. A remedial measure is one that either aims at correcting past harm, so rectifying a situation that has occurred, or preventing similar harm from happening in the future. Importantly, any remedial measure that is imposed by council cannot conflict with existing law, and this includes the provisions of the Municipal Act. Other actions that are imposed by council also cannot be punitive in nature, or they cannot be sanctions that are disguised as remedial measures. There was a case out of a town just north of Toronto called Whitchurch-Stouffville, where in response to a code of conduct breach finding, the council imposed significant, what they called remedial measures on the then mayor, including preventing him from accessing facilities at town hall, preventing him from attending any municipal facilities whatsoever, including things like pools, libraries, and requiring him to turn in his chain of office. The court found in those instances, based on the harm that was found in the report, those provisions or those remedial measures had no connection to the harm that was done. So any remedial measure cannot try and punish the member for what they've done. That's why we have the penalties in the Municipal Elections Act, or sorry, the Municipal Act, I should say. And the penalties cannot be motivated by a desire to mete out justice or retribution as against the member. They must be aimed at correcting some harm that's been done or preventing the same harm from happening in the future. That brings me to the end of my presentation, members of council. So I'll I'll stop sharing my screen there, and I'll turn the floor over to you, Madam Mayor, should there be any questions.
Are there any questions from members of council? Councillor Eby?
I'm very sorry, Madam Mayor, I can't hear Councillor Eby.
Sorry about that.
I can hear you now.
The recommendations put forth by the Integrity Commissioner, with the two incidents that were referenced as being substantiated, are they based upon preventative failure, preventing future harm, for example, when it comes to suggesting that a councillor not represent the township at external committee meetings, say at the hospital? Is that the rationale for that kind of recommendation?
So through you, Madam Mayor, without understanding what was in the Integrity Commissioner's mind when crafting those recommendations, that is something that Council itself has to turn its mind to. Council has to be certain, in order to impose these measures, that there is a very clear, definable connection to preventing future harm related to the code of conduct issue, not related to general reputational issue or general judgment of whoever may be involved, but it has to relate specifically to the issue at hand.
Are there any other questions? I do have a few. Okay, so I'm hoping if you can answer them. If not, then just please let me know. Okay, now that we've received this IC report and it's a public document, can you tell me who pays for this report?
Certainly, Madam Mayor, in accordance with the Municipal Act, the activities of the Integrity Commissioner are funded by the township.
Okay, so by the township, that means the taxpayers.
Yes, any revenue that the township may derive.
Okay, so just like you're here tonight and E4M, the bill for this IC report includes all emails, text messages, phone calls, Zoom meetings, in-person interviews with any and all persons involved in this matter, and that includes legal communication with your office, with E4M, Councillor Brand's legal representation, travel cost, all of that. That's all included, would be included in the bill from the IC, correct?
Madam Mayor, yeah, presumably yes, although I don't know the specific details of any contract that might be in place governing what expenses might be covered. But yes, the entire investigation process, start to finish, would be included in that in those costs.
Okay, thank you. And that's about 7 months. Is it the township's obligation to report in open session of council the full cost of this report?
Madam Mayor, I don't know that there's necessarily an obligation to do so. Council could, if it saw fit, if there was a resolution passed, report that. But I don't see that there's an obligation to do that.
Okay. Hey, is there any policy or section in the Municipal Act that allows a township to make a policy moving forward from this? If an IC complaint is found to be unsubstantiated, the complainant would have to cover the cost of this report? Like, is that anybody have that in Ontario, or that's just not legal?
No, Madam Mayor, I'm not aware of any policy to that effect. I'm aware of fees to file an application, but not to pay for an unsubstantiated complaint, nor do I think that would meet the purpose or be coherent with the purpose of why we have this regime in place.
Okay. Okay, so tonight we're going to be discussing the integrity report. Are we allowed to express our feelings or make comments just on the substantiated and unsubstantiated findings during this report? I'm just trying to prevent any future legal challenges.
Certainly. So, Madam Mayor, as I mentioned in my presentation, Council's role is to determine the appropriate sanction. To the extent that exercise requires consideration of what the harm does or what the harm was and how severe it was, that may be in order. Commenting generally or of a general nature wouldn't really fit with what Council's role is at this juncture, because ultimately this is, to use criminal law terms or to compare it to criminal law, which this is not, but this is a sentencing consideration. And part of that is looking at the harm that's been done, the severity of the actions, and what is required to be put in place to respond appropriately to those contraventions.
Okay. Last one. As you can understand, my concern when a councillor can submit complaints with no proof or merit, and it costs the township, I mean the taxpayers, thousands and thousands of dollars. In your opinion, if Bill 9 was law today, going off of this IC report, would Councillor Brand's serious violation of code of conduct meet the threshold of having her vacate her seat on council? If you can speak to that, because that is coming into law in the fall.
Certainly, Madam Mayor, very, very astute of you to take note of Bill 9. That has been passed by the legislature, but not in force as of yet. I'm not certain one way or another whether that would meet the threshold, and that's a determination that the Integrity Commissioner would have to make. And there's subsequently a process for vetting or for checking that determination, including the involvement of the Ontario Integrity Commissioner.
Okay, thank you for that. Seeing no more questions from council? No, okay, thank you very much. Very informative.
Thank you, Your Worship.
Thank you. Have a good evening.
Thank you, you as well.
Okay, so now we're going to move on to E4M, the Code of Conduct report. Good evening, Sean.
Good evening, Your Worship. Did you want me to just get started, or?
Sure.
Okay. Thank you for having me here tonight, to Mayor and Council, and thank you to Mr. Pappas. That was really well done. What I propose doing, Mayor Robinson, is I'm going to read my report, and I'm going to apologize at the beginning just to the length of it. It's probably going to take me an hour or more to read it all in. What I'm going to do is there may be certain portions that I skip over. Mr. Pappas just did a very good job of explaining where the authority for the Integrity Commissioner comes in, so I don't propose reading that even that first page of the report. It's been explained. At a certain juncture, there may be some commentary I might put in that's come to light since the report was authored, and I'll be available for any questions or comments you have at the end. But if there's something in the interim, even if you need to take a break, please just interject, and I'm happy to do so. Okay?
Sounds good. Thank you.
Okay, thank you. Okay. So I'll skip through the first preamble of the report on page 4, and I start at the standard of proof. The test for making factual findings is whether or not the alleged conduct occurred on a balance of probabilities. This means determining whether or not it is more likely true than not that an alleged conduct occurred. This is a lower threshold than the criminal standard of proof beyond a reasonable doubt. Credibility and reliability. Appendix A to this report contains a detailed analysis of the credibility and reliability of the key parties in this matter. All of the parties except Councillor Brand were found to be both credible and reliable. Councillor Brand was found not to be credible or reliable, and that at key junctures she provided false and misleading information to the investigator. The allegations received by E4M after their appointment as the Integrity Commissioner in December 2025 and subsequently referred to the investigator were substantiated. Some related to the alleged contraventions of the Occupational Health and Safety Act. These allegations were thoroughly investigated, and an interim report outlining the findings of the investigation were presented to Council in closed session. I just want to say that might be just a bit misleading, Mayor Robinson. I didn't present it personally. I believe it was presented or provided by staff. The content of this report is protected under the OHSA and the Municipal Freedom of Information and Privacy Act. The report provides details that the Integrity Commissioner believes to be necessary to report to Council and the public. The history and the background. In 2023, 2 municipal employees, here referred to as employee number 1 and 2, filed workplace complaints against Councillor Brand related to conduct she engaged in directed at these employees. These allegations are similar to the ones before the Integrity Commissioner now, and due to their confidential nature, we are only providing this information for context and will not disclose which employees lodged the complaints or the general natures of the allegations, other than to state that they were also thoroughly investigated and findings reported to Council. Of import and germane to this inquiry is that Councillor Brand was found to have violated workplace policies of the municipality as well as the OHSA during the previous investigation. These complaints were the first in a long list of complaints involving elected officials in Red Rock, dealt with by the previous Integrity Commissioner. Historically, several complaints against members of Council were received and reviewed, but were not publicly reported on other than the findings against Councillor Brand set out above. The remaining unreported complaints were mainly allegations of code of conduct violations made by various members of council against one another. These complaints were resolved through a mediation process recommended by the former Integrity Commissioner and agreed to by the involved parties. The mediation process ended around December 2024. The purpose of the mediation process was for all involved to find common ground to function more effectively as an elected body and as a better path forward than a formal inquiry process, and in doing so, all the complaints they had made would be withdrawn. More will be said about this mediation process later in the report. The complaints received by the previous Integrity Commissioner in late 2025 later referred to E4M and considered in this report start with the initial workplace complaints lodged against Councillor Brand in 2023. Further, the current complaints alleged and continued pattern of behavior by Councillor Brand directed at employee number 1 and employee number 1's family, which includes employee number 2. These initial complaints were filed by employee number 1 and a ratepayer for the municipality. After the new complaints were made against Councillor Brand in November of 2025, Councillor Muir and Councillor Smith requested that the complaints mediated previously in December of 2024 be reinstated and then fully considered as if the mediation had not occurred. There are provisions in the Integrity Commissioner protocol for the municipality to do this under certain circumstances. As explained elsewhere in this report, the Integrity Commissioner declined to reopen these older complaints. At the outset of our inquiry process, we received complaints from Councillor Brand, from employee number 1, a ratepayer, Mayor Robinson, Councillor Muir, and Councillor Smith. After becoming aware of these complaints, Councillor Brand in turn filed several complaints against Mayor Robinson, Councillor Muir, and Councillor Eby. During the inquiry, the investigator also became aware of additional allegations regarding Councillor Brand and one further allegation against Mayor Robinson that were dealt with in this report. In all, there were over 30 separate allegations made against elected officials of the municipality forming this inquiry. The following is our analysis and findings. The inquiry process. Upon review of the allegations, we prepared an investigation strategy and notified all complainants of the inquiry and their requested participation and cooperation. Once all complainants were interviewed and their supporting evidence was submitted, we then interviewed the witnesses. Interviews were recorded and transcribed. The allegations were then put before each respondent to allow them an opportunity to provide their response to the allegations and submit any supporting evidence. On several occasions, we returned to the respondents to respond to additional evidence received during the course of the inquiry. We received and reviewed a variety of documentary evidence from all parties. The actual recorded meetings were available and the statements of those interviewed. We conducted credibility and reliability assessments of all involved parties. The credibility and reliability of the participants in this inquiry were then assessed and weighed against available evidence in order to arrive at our findings. The credibility assessment are attached to this report at Appendix A. Findings with respect to the allegations are based on the civil burden of balance of probabilities. Balance of probability simply means that a fact is considered to be true or proven if it is found more likely to have occurred than to not have occurred. One of the initial steps to the inquiry that we undertook was to distill all of the complaints into categories and determine which ones would proceed to investigation. For example, the inquiry did not open any of the historical matters that were part of the mediation process with the previous Integrity Commissioner. This meant the inquiry would only consider matters after December 2024. There are several such complaints made by Council Muir, Smith, and Brand. The inquiry did not consider any complaints made about staff members, which were all made by Councillor Brand. The inquiry lacks jurisdiction to conduct such investigations. They are the responsibility of the municipality and/or council as a whole. The inquiry did not consider allegations that on initial review could not amount to misconduct, even if all elements of the allegations were proven. Only allegations that were investigated are included in this report. The decision on jurisdiction of the historical complaints. The previous Integrity Commissioner for the municipality was Mr. Daryl Matson. He received several complaints from elected officials in early 2024. As part of the inquiry process, Mr. Matson received submissions from the parties involved. One of these submissions was from legal counsel for Councillor Brand, Mr. Judson. Mr. Judson suggested to Mr. Matson that all the matters could potentially be resolved by way of a global resolution, meaning a mediation between the parties. Mr. Matson then made this offer to Mayor Robinson, Councillor Muir, and Councillor Smith. Everyone agreed to the mediation as a form of complaint resolution. Councillor Muir and Smith submitted to the President Integrity Commissioner that they wanted to reinstate the old complaints that were part of the global resolution. This was based on understanding that they had from the previous Integrity Commissioner. They could do so at a later date if they chose to. Councillor Brand was advised of this request as part of the new matters. It was at this time that Councillor Brand wanted to proceed with the old complaints as well. Mayor Robinson did not wish to revisit the previous matters. The Integrity Commissioner protocol does allow for mediation and for the parties to return to the formal complaint process under certain circumstances. Bylaw 2023-1336, the Integrity Commissioner Protocol, Section 4, Approved Complaints Response Investigative Procedure. This is a quote from that bylaw. Regardless of the type of complaint, an informal resolution may be possible even after the formal proceedings has begun. The Integrity Commissioner will, if the parties agree, attempt to resolve the matter informally. Should an informal resolution remain elusive, the formal procedure will recommence. It was based on this wording that the previous Integrity Commissioner attempted to mediate the complaints before him. He received agreement from all the parties for this process. The process agreed to by elected officials was to engage an external mediator for a structured conversation. This is a very common practice to resolve conflict in professional settings. This process was well laid out by Mr. Matson in correspondence to Council. Council followed the steps laid out for the mediation. On December 23, 2024, Mr. Matson wrote to Council advising them, "Thank you, Red Rock City Council and CAO, for the cooperation and individual efforts received throughout the investigative process. Your cooperation assisted greatly in bringing files number 2024, was file number 1, 2024, and file number 2, 2024 to an informal resolution. As of December 17th, 2024, I consider these two files concluded and closed." The CEO at the time was Mr. Mark Figliomini. He came back to Council with recommendations and a facilitator was selected. These discussions continued into January 2025. On February 21st, 2025, the Integrity Commissioner wrote to Council. He advised them that he had received 3 emails from members of Council expressing concerns with respect to the informal resolution in which members of Council wanted to reinstate the complaints and abandon the mediation process. He also received communications from the CAO requesting on behalf of Council to put any of the mediation efforts on hold. On March 24th, 2025, the Integrity Commissioner wrote to Council regarding his decision not to reinstate the old complaints. His reasonings were as follows. With respect to the 2 complaints, an informal resolution was achieved by way of an interim report, and a global resolution was achieved when Council approved retaining a workplace facilitator. It is clear from the interim report and subsequent letter on December 23rd, 2024, that the IC considered these matters to have been resolved through the informal process and therefore closed. If new applications are submitted and they seek to reinvestigate the same events as those included in file number 1, 2024 or file number 2, 2024, the IC would have to separate those events from the new events and conduct an investigation into the new events only. The present Integrity Commissioner finds that it lacks jurisdiction to review a decision made by the previous Integrity Commissioner. It is not the role of an Integrity Commissioner to sit in what amounts to be an appeal of another Integrity Commissioner's decision. There are venues for such an appeal, and that process is not with the present Integrity Commissioner. The present Integrity Commissioner does adopt the position of Mr. Matson and agrees that this matter was concluded when the parties agreed to and took steps to complete the mediation process. Mr. Matson's guidance that the new complaints post-December 24 would be investigated is well reasoned and is adopted by the current Integrity Commissioner. The request to reopen the previous allegations of misconduct is denied, as the present Integrity Commissioner lacks jurisdiction to consider this request. Only matters that have occurred after December 2024 have been considered in this report. Historical matters will be considered for context only. The historical context. There is a long backstory to these matters. It does not appear to be any one issue that caused a breakdown in the relationship between the parties. However, it is clear it has occurred, and it is unlikely that this report or any form of mediation will be effective in repairing the relationships involved. The conflict does appear to start around Councillor Brand's employment with the municipality of Red Rock. She was employed by the municipality in the months prior to being elected to council. This employment ended prior to the election, and there was evidence that she blamed her employment status to a degree on employee number one. This appears to be in part the catalyst for the harassment directed at employee number one and her family by Councillor Brand and by one of Councillor Brand's close family members. Employee number 1 and 2 filed workplace harassment complaints against Councillor Brand that are not part of this report, except as part of this historical background. The allegations were investigated under the Occupational Health and Safety Act. Councillor Brand was found to have violated the OHSA in relation to her conduct directed at both employee number 1 and 2. Due to the privacy reasons for the OHSA matters, the Integrity Commissioner is unable to provide more details on what exactly occurred to substantiate these findings of misconduct against Councillor Brand. The original complaints in these matters, was filed in August of 2023. Councillor Brand has a close family member who in the past was friends with employee number 1 and 2. It is unclear exactly why this friendship ended. There are likely a number of factors contributing to this. This family member has been engaged in a relentless harassment of employee number 1 and number 2, Mayor Robinson, and members of council. The Integrity Commissioner has been provided with extensive social media posts created by Councillor Brand's family member that directly attacked these individuals. The harassment by the family member was prolific and lasted for a number of years. During this harassment, the family member lived across the street from employee number 1 and her family. A very important background fact is that at the time of the present allegations, Councillor Brand's family member was charged criminally with several offenses. These included criminal harassment of employee number 1 and her family. The family member was essentially banished by the courts from living in proximity to employee number 1 and her family pending trial. This meant that they could not reside across the street from employee number 1 for a long period of time awaiting trial. The criminal charges involving Councillor Brand's family member have since been resolved. They are now bound by a Section 810 Criminal Code peace bond with several restrictive conditions to protect employee number 1 and her family. Employee number 1 provided extensive details as to the harassment and the impact on her and her family to the investigator. These details have not been reported in this report. However, it was visibly traumatizing to her. Employee number 1 and her family eventually moved from Red Rock to avoid the ongoing harassment by Councillor Brand's family member. It is under this historical context that the allegations addressed in this report occurred. Members of council believe that Councillor Brand should have been able to address the harassment with her family member and chose not to. Others felt that Councillor Brand was working in concert with the family member to harass employee number 1, her family, and council as a whole. Councillor Brand felt that council as a whole was against her, and she should not be expected to manage the conduct of an adult family member. This all culminated in a Facebook post around November 7 to 11, 2025, where Councillor Brand's family member asked for someone to provide proof that employee number 1 and her family have moved from their residence. Around the same time, employee number 1 was being contacted by the Crown Attorney managing the criminal charges against Councillor Brand's family member. This family member, through the legal counsel, was aware that employee number 1 and her family were moving from Red Rock. They wanted a bail variance in order to move back home. One of the allegations is that Councillor Brand then parked out front of employee number 1 and number 2's residence to gather evidence requested by the family member. By chronology, the allegations from November 2025 occurred towards the end of all the matters covered in this report. It was after these allegations that the balance of the complaints was made by the respective parties. This report presents allegations by respondent. Allegations against Mayor Darkis Robinson. The following are the allegations made against Mayor Robinson. Allegation number 1. This has been broken into 2 separate events. November 1st, 2025, and this is a hashtag, and I apologize for the language, but the hashtag is #FuckRobinson. On November 7, 2023, Mayor Robinson posted to Facebook on behalf of the municipality messaging on anti-bullying or harassment of township staff. Councillor Brand alleged that Mayor Robinson went against her own messaging in this post by directing the following inappropriate messages at her family member in 2025. On November 1st, 2025, it was alleged that Mayor Robinson posted an image to Facebook in which she was wearing a shirt with the hashtag #FuckRobinson. In this image, she was holding a drink container with the same wording on it. In the Facebook post, she stated IYKYK, which means if you know, you know. Councillor Brand alleged that the if you know, you know is directed at her family member, and that this messaging as a whole contradicts the post made by Mayor Robinson in 2023 about anti-bullying harassment in the municipality. November 4 through 19, 2025, derogatory emails by Mayor Robinson to Councillor Brand's family members' legal counsel. Councillor Brand further alleged that there was a variety of emails and correspondence on this matter where Mayor Robinson contacted her family members' legal counsel for the criminal charges. She alleged that these correspondence by Mayor Robinson used derogatory language about the issue. The following is a summary of the evidence. On November 1st, 2025, a social media post was made by Mayor Robinson. Councillor Brand stated the post contained messaging that she believed was directed towards and critical of her family member. Councillor Brand indicated the post included language and imagery that she felt was targeting and mocking her family member. She stated that this was not an isolated occurrence, but formed a broader pattern of social media activity, which she viewed as inappropriate and unprofessional for her members of council. The social media post was posted by Mayor Robinson on November 1st, 2025, was a picture of Mayor Robinson wearing a black sweater holding a drink container, and both had the hashtag #FuckRobinson on them. The caption in the post reads, quote, November 1st, and we are starting off strong. And if you know, you know, let's go Blue Jays. Councillor Brand characterized the conduct by Mayor Robinson as harassment or bullying directed at her family member, particularly given the nature of the platform. Councillor Brand felt that Mayor Robinson was targeting a private individual connected to her as a member of council. In a response to these allegations, Mayor Robinson provided that on November 1st, 2025, she was given the sweater and drink container by another person. When they were given to her, they had the hashtag on them. The person who gave them the items used Mayor Robinson's phone to take a picture of her wearing the sweater and holding the drink container. The same person then posted the image to Mayor Robinson's Facebook account. The hashtag in question was not created by Mayor Robinson. She advised that it was created about 2 years prior to November 1st, 2025 by Councillor Brand's family member. The hashtag and a number of variants were used repeatedly by Councillor Brand's family member to harass Mayor Robinson in several derogatory social media posts. Mayor Robinson indicated that she had never responded to Councillor Brand's family members' use of these hashtags online or publicly. She has had several citizens in Red Rock come up to her laughingly and say, "Fuck Mayor Robinson." It has become an unfortunate part of her identity. This has been very upsetting and has negatively impacted her and her family. Mayor Robinson explained that neither she nor anyone on her behalf has responded to Councillor Brand's family members' harassment. These items were given to her and posted to Facebook in good fun, and she does not see the issue with them given where the hashtag originated from and the impact they've had on her. The person who created the sweater and the drink container did it as they knew the harassment Mayor Robinson was subjected to by Councillor Brand's family member. Mayor Robinson provided several screenshots of social media posts from Councillor Brand's family member using the various hashtags. These posts show a repeated use of the derogatory hashtags. They are used multiple times to attack Mayor Robinson in her professional capacity as the mayor of Red Rock. There were also a number of private messages sent to Mayor Robinson and her family by Councillor Brand's family member. These were equally offensive as the public hashtags. Councillor Brand stated that Mayor Robinson communicated directly with legal counsel representing her family member in connection with ongoing disputes involving the town. She indicated that multiple letters were sent and further stated that at least some of these correspondence were derogatory in nature. Councillor Brand expressed concerns that these communications reflected bias and an inappropriate tone, particularly given the mayor's roles and responsibilities. She indicated that, in her view, such correspondence contributed to the escalation of conflict and raised questions about the impartiality in matters involving her family member. Councillor Brand was asked to produce the alleged derogatory correspondence by Mayor Robinson that she was referring to. The investigator subsequently received correspondence from Mr. Judson, counsel for Councillor Brand, advising that it was Councillor Brand's family member who gave her this information, and that Councillor Brand did not have the actual correspondence that formed the basis of the allegations that she was making. All of All the emails referenced in this section were sent to the investigator by Mayor Robinson. Mayor Robinson also provided the investigator with the emails that she sent to her employer. They have been reviewed only in order to make a determination on whether or not there is jurisdiction to consider these materials. For example, around November 19th, 2025, Councillor Brand's family member posted a derogatory post to Facebook identifying Mayor Robinson and her employer. This post also made a number of disparaging remarks about the former CEO. At the bottom of the post, it states, hashtag Mayor Robinson, and then I've redacted from the report is even worse, deplorable human beings. The redacted portion is Councillor Brand's family member listing Mayor Robinson's employer. On November 19th, 2025, Mayor Robinson sent this post to her employer from a private email account. She did not send it in her role as mayor, but rather as to her employer as their employee for their awareness. The investigator finds that it lacks jurisdiction to review these emails further, as they were not created in her official capacity as mayor. There is no nexus between Mayor Robinson's role as mayor and her employer in these emails. November 4th, 2025. Mayor Robinson sent 2 emails with multiple Facebook posts made by Councillor Brand's family member to the family member's legal counsel, who was representing her on the criminal harassment charges involving employee number 1. The post accused the mayor and council of covering up the theft of $400,000 from the municipality. They specifically singled out Mayor Robinson for these attacks. I'm just going to pause there. It's not on the report. This $400,000 theft came up a number of times from this individual and from others that I saw social media posts, and from discussions with the municipality and staff and whatnot. It's quite clear to me that this is not true. This is just people bringing up something derogatory against council. It's quite obvious that council had proper processes in place for this money, and this is just fictitious posting by this individual. They specifically centered out Mayor Robinson in their attack. Mayor Robinson email stated the following: Miss redacted. This is the name. What's redacted there is the actual name of the individual. Continues to name employees of the township, including the CAO, which I must say she is quite happy to see him resign. What's interesting is she posted just 2 days ago how in-camera session was going to be good. Is she really serious about resolution with a trespass order? I have supplied some of her random posts just so you're aware of it. Miss does have a lot going on with her criminal charges and her inability to come into Red Rock without her surety over the past year or so. I have notified my employer of Miss comments about me online because she has included her employer in the post. Miss continues to accuse me of bullying, but must look in the mirror. What she's doing is no different. Miss, I needed to get this off my chest. Sorry, Mr. That's the lawyer's name. Get this off my chest about Miss continues to talk about both sides of her face. Either you want to be better and stop harassing people or you don't. I personally think she's so used to this conflict, she thrives on this. I wish you the best and hope she is able to move into a more healthy social media presence. November 5th, 2025, Mayor Robinson sent a Facebook post from Councillor Brand's family member to the family member's lawyer again. This post calls for the fire department of the Township of Red Rock cowards and makes derogatory statements. When sending this email, Mayor Robinson stated, today, they're going over old Facebook posts and making comments. Again, negative comments about current staff and false accusations, and yet again comments about the fire department. When will this end? And some accountability on their part. The following is the post on the anti-bullying made by Mayor Robinson in November 7th, 2023. There has been an increase of online harassment and bullying towards employees of the Township of Red Rock. Incidents of harassment include following staff to work, taking videos and pictures of staff and their residents, and taking pictures of their children. There has also been an increase in dropped phone calls at municipal office with caller ID blocked. When administration and council are made aware of these incidents, we take them very seriously. It is the duty of council to provide municipal staff with a safe working environment that includes online harassment as well. Speaking to the residents of Red Rock and their family, if you see this type of behavior online, we ask that you please disengage. Sincerely, Mayor Robinson. The analysis. It was alleged that Mayor Robinson breached the code of conduct for elected officials found in bylaw 23-1336. Specifically, it's alleged that she contravened Section 3 sub 2 the standard of conduct, which reads, it is understood that attaining an elected position is a privilege which carries significant responsibilities and obligations. It is further understood that council members are to be held to a higher standard of behavior of conduct than the general public. Council members must be independent, objective, and responsible to the people. Members are to be expected to act with integrity and fairness that will bear the closest of scrutiny. And then there's a piece on not engaging in harassment. Harassment means not engaging in a course of vexatious comment or conduct that is known or ought reasonably known to be unwelcome. And it talks about being part of the Human Rights Code and Occupational Health and Safety Act. And there's an 8-point list of items that they're not to engage in. We have been provided with an extensive social media post made by Councillor Brand's family member. To say they're extensive is an understatement. Many of the posts are replete with half-truths, misleading or false information, and are very harassing towards members of council, staff, and the municipality, and so on. The conduct by this person, coupled with their in-person actions, resulted in various criminal charges against them for conduct against staff, members, and members of the public. These are the charges that resulted in the Section 810 peace bond in the criminal code in order to protect employee 1 and her family. This individual has personally attacked Mayor Robinson and others for a long period of time on social media. Their actions are such that they demanded a response and actions by Mayor Robinson to protect herself, her family, and members of council and staff. Councillor Brand's family members' comments such as creating a hashtag "fuck Mayor Robinson" are deeply offensive. The individual making the social media post and Councillor Brand had to expect a response from the people being targeted in these posts. The conduct alleged by Councillor Brand is extremely minor compared to that of the family member and was done in a response to repeated harassment targeting Mayor Robinson. On March 9, 2026, the investigator contacted Councillor Brand's family member and attempted to interview them as part of this inquiry. They refused to participate. On June 1st, 2026, we were informed that Councillor Brand's family member had again posted to Facebook an article about the cost of hybrid voting for the coming election. Their post is again full of accusations and innuendos that are false and misleading. In this post, they again use the hashtag #FuckMayorRobinson. I'll pause for a second. I was advised that again last week this has continued to occur, that this individual is still using these hashtags in relation to Mayor Robinson. Mayor Robinson described in detail the impact the conduct of this individual had on her. She explained that when she received the sweater and drink container as a gift, and it was that person who took Mayor Robinson's phone, took the picture and posted it to Facebook. We noted the image does not identify anyone. How it's very accurate to say, if you know, you know, regarding the point of the imagery on the sweater. We know that this individual has made a very vile sport out of harassing a variety of people in the municipality. Everyone knows that this has been going on for years. Mayor Robinson did not create the sweater or the drink container with the hashtag. She also did not post it to social media, although it was on her social media account. The actual hashtag was simply restating the harassment she had to endure. It was also a form of levity directed at herself. It was a very muted response. There is nothing offensive about Mayor Robinson pointing this out in the way that she did. Mayor Robinson did not direct anything offensive to another person. She simply restated what had been posted to social media about herself. We also reviewed the email correspondence by Mayor Robinson to the lawyer representing Councillor Brand's family member. There is nothing offensive in the text of these emails. It's very concerning that Councillor Brand would make such accusations without having the actual information it was based upon. Mayor Robinson's detailed information on this issue served to clear the air on what would otherwise have been accusations that would have lingered for some time. In contacting the legal counsel for Councillor Brand's family member, Mayor Robinson was acting in her capacity as the head of council. It was within her purview to attempt to stop the behavior of Councillor Brand's family member. In the email to the lawyer, Mayor Robinson was professional, stated facts, and her conduct was not offensive in any way. The finding: Mayor Robinson's actions are not offensive in any way and merely stated facts related to the harassment she had to endure. These responses by Mayor Robinson were surprisingly very muted and measured. The allegation that Mayor Robinson violated bylaw 2023-1336 are unsubstantiated. Allegation number 2, conflict of interest. It was alleged that on 17 November 2025, there was a closed session of council. At this meeting, Mayor Robinson declared a pecuniary interest in matters involving Councillor Brand's family member. It is alleged that she then failed to leave the meeting when the matter was discussed by council. Councillor Brand provided a written submission and was interviewed on this allegation. Her evidence was that on November 17, 2025 meeting of council, she, being Councillor Brand, declared a pecuniary interest in relation to agenda items concerning employee number 1 and legal update involving the trespass notice connected to her family member. Following this declaration, Councillor Brand exited councillor chambers at approximately 6:43 p.m. in accordance with the requirement that a member with a conflict remove themselves from the discussion. Councillor Brand further indicated that the legal counsel for her family member had previously requested that Mayor Robinson remove herself from any discussions relating to her family member. Notwithstanding this request, Mayor Robinson did not recuse herself from participating in the meeting of November 17, 2025 closed session. Mayor Robinson was also interviewed on this allegation. Her evidence was that she had in fact submitted a written declaration recusing herself from the discussions involving Councillor Brand's family member. She further indicated that she intended to leave the closed session of council. However, when the matter arose, there was no longer a quorum to discuss the matter, as both she and Councillor Brand had recused themselves for separate reasons. The matter was then deferred to a later date for discussion. We sent correspondence to Councillor Brand and her legal counsel. They were asked if it was possible there was no quorum for the meeting on the date Councillor Brand alleged Mayor Robinson failed to recuse herself from the meeting. The following is the response received from Mr. Judson on Councillor Brand's behalf. In respect of the November 17, 2025 meeting, it is not possible that the item of business was simply deferred and no substantive discussions occurred given the length of time that transpired during which Councillor Brand was not in the room. Councillor Brand believes that Mayor Robinson spoke to the item despite her apparent conflict. We obtained the relevant meeting minutes and declarations from the November 17, 2025. We also reviewed the published minutes for the closed section as well as the clerk's handwritten notes. The public minutes state, report from closed session. Council approved the closed session minutes for November 3rd, 2025 council meeting. Council discussed items relating to identifiable individuals and deferred 2 items to a later date. In the clerk's notes for the closed session, November 17, 2025, they went into closed session at 6:31 p.m. First point, Councillor Brand declared a conflict of interest on the items. And then item number 5, Councillor deferred items. Mayor Robinson declared, Councillor Brand declared no quorum. The Integrity Commission also reviewed the matter that required Mayor Robinson to declare a pecuniary interest for this meeting. It relates to the matters involving Councillor Brand's family member. Mayor Robinson declared the conflict after receiving correspondence from legal counsel for Councillor Brand's family member. This all related to whether Councillor Brand related to when Councillor Brand contacted the lawyer about Councillor Brand's family member's conduct in the social media post. Although Mayor Robinson declared a conflict of interest, it appears to have been done out of an abundance of caution on her part. In reality, there was no pecuniary interest of any kind relating to Mayor Robinson and Councillor Brand's family member. This meant there was no legal reason for Mayor Robinson to recuse herself from the closed session of council on November. There's a typo, it should be November 17th, 2025. Mr. Judson's submission on behalf of Councillor Brand regarding the issue of quorum and hypothesizing there had to be conversation is speculative and not supported by the evidence. Analysis. It is alleged that Mayor Robinson failed to leave the meeting of council on November 17, 2025, after having declared a pecuniary interest on a matter involving Councillor Brand's family member. The evidence does not support Councillor Brand's allegation. The matter in which Mayor Robinson declared a pecuniary interest was not discussed on November 17, 2025, and it was deferred to another date due to a lack of quorum. This is evident in both the public minutes of the meeting and the clerk's notes. The Code of Conduct for Elected Officials under Bylaw 2023-1336 does not have specific language about the situation alleged by Councillor Brand. The Code of Conduct essentially directs members to follow the Municipal Conflict of Interest Act. Finding, based on the balance of probabilities, the allegation that Mayor Robinson was a conflict of interest during the closed session of council for November 17, 2025 is unsubstantiated. Allegation number 3, breach of confidentiality. On May 10, 2026, Mayor Robinson emailed the investigator. She was concerned about the ongoing conduct of Councillor Brand. She had learned that Councillor Brand had contacted a local reporter and had requested all copies of recent stories that had been written about Red Rock that included comments by Mayor Robinson. The reporter indicated that he did not provide the requested information, which led Councillor Brand to contact his boss in Thunder Bay. Mayor Robinson's evidence included 3 screenshots of the text conversation with the reporter. The text messages revealed that the reporter also asked Mayor Robinson if she was running for office again this year. The following is the exchange from this point of the conversation. Mayor Robinson, 90% out the door. Reporter, obviously, you haven't filed yet. Mayor, no, I haven't. We have an Integrity Commissioner report coming out in a few weeks, so a lot depends on that. Reporter, yikes, people are being assholes, ? Mayor, councillor now claiming I'm harassing her family member who gave me the fuck Mayor Robinson. LOL, yeah, I'm the harasser. Reporter, who is Cindy Brand? She emailed me, wanted a copy of all my recent stories about Red Rock with your comments emailed. Mayor, how long ago was that? She's nuts. Reporter, just last month, 3 weeks ago, after the last council meeting. Mayor Robinson was asked to explain why she disclosed the confidential investigation to a reporter and made a remark about Councillor Brand being nuts. She advised that the reporter was a close friend and that the remark was made between friends. Councillor Brand was asked why she was contacting the reporter for information about Mayor Robinson in the midst of an Integrity Commissioner investigation. Councillor Brand did not respond directly to these questions. Instead, Mr. Justin responded on her behalf. The investigator explained that on the surface it appeared that Councillor Brand was attempting to generate further complaints about Mayor Robinson or potentially interfering with the investigative process. The investigator has some back and forth email communications with Mr. Judson on this issue, where Mr. Judson challenged the jurisdiction of the Integrity Commissioner to request this information from Councillor Brand. The investigator submitted the following to Mr. Judson. It is followed by Mr. Judson's response. Councillor Brand has never provided a direct response to this topic. May 31st, 2026, spiraling to Judson. I disagree with this submission. Councillor Brand is in the middle of an inquiry while both complaining about Mayor Robinson and being the subject of the complaints from her, and contacted a member of the media to obtain additional information about Mayor Robinson. This is irrelevant to the present matter. It is your decision to cooperate with this request or not. If you choose not to participate, if you do choose to participate, I'll need all the correspondence with the reporter, as well as an explanation as to why this occurred given the context above. June 10, 2026, Judson is spiraling. We maintain our position regarding Councillor Brand's contact to the media or her alleged efforts to find information about the activities of a public office holder. None of that on its own is prohibited by the Code of Conduct. Members of council are permitted to make inquiries about the performance of their peers around the council table and communicate with third parties about other members of council. You have no jurisdiction here unless there's a specific complaint about Councillor Brand's communication. If you were to assume jurisdiction, we would challenge your report with legal action against the municipality under Section 2B of the Charter as an unjustified incursion into Councillor Brand's freedom of expression. The fact of receiving a bare complaint does not open the door to a probe into every communication the council member had with third parties unless you have particulars of a contravention of the Code of Conduct of the Municipal Code of Conflict of Interest Act that it pertains to. Analysis. Bylaw 2023-1336 Code of Conduct for elected officials has explicit language on the duty of elected officials to maintain confidentiality of information they receive in the course of their duties. Only the relevant section has been provided here in this report. Confidential information. Every municipal council member must hold in strict confidence all information of a confidential nature acquired in the course of his or her term with the municipality. The following should be considered breaches of the Code of Conduct. To use confidential information was not available to the general public and to which members of council have access to by reason of their position with the municipality to further his or her personal interest or interest of others, to disclose to unauthorized persons confidential information to which members of council has access by reason of his or her position by a member of council with the municipality. The Municipal Act under 223.5 sub 2, the Integrity Commissioner and every person acting under the instruction of the Commissioner shall preserve secrecy with respect to all matters that come to his or her knowledge in the course of their duties. The Code of Conduct also states, Council members, this is under section 4. Council members will speak respectfully of each other, staff, municipality, and all council decisions. Councilors will not comment on other members or staff in the manner which casts aspersions on their professional competence or credibility. The evidence on this matter is clear. Mayor Robinson discussed a confidential Integrity Commissioner investigation with the reporter. This occurred on May 9, 2026, and was self-reported by Mayor Robinson. She disclosed the existence of the investigation, that she was the subject of allegations, including that she has harassed someone. She did not identify Councillor Brand. However, when the name was brought up to her, she described Councillor Brand as nuts. Finding, based on the balance of probabilities, the investigator finds the allegations that Mayor Robinson breached section 4. I should read section 4 and 5 of bylaw 2023-136 by disclosing confidential information she received about the investigation and by referring to Councillor Brand as nuts is substantiated. There is no finding in relation to Councillor Brand contacting the reporter to solicit information about Mayor Robinson. Given the context and the backgrounds of these matters, her actions are highly suspect and indicative of her overall conduct. Allegations against Councillor Chris Eby. Councillor Brand.
Excuse me, Sean, I just want to let you know that we do have your report up on the screen.
Oh, okay.
So we can see it here, and then anybody watching it online, just so you're aware. Okay.
Okay. Yeah. Did you want me to continue reading it, or?
Do whatever you'd like to do. You present how you planned.
Okay, I'll keep reading through them. Councillor Brand made a series of allegations concerning interactions with Councillor Eby. She alleged that on February 18th, 2025, during discussions related to Facebook posts made by her family member, Councillor Eby addressed her and stated that if her contributions were 10% positive and 90% negative, she should reconsider her role on council. She characterized this remark as belittling and inappropriate. Councillor Brand further alleged that in beginning of September 15, 2025, Councillor Eby engaged in ongoing conduct relating to seating arrangements in council chambers by occupying a seat customarily used by her. She alleged that when the matter was raised, she stated, "You are in my seat," to which Councillor Eby responded, "I thought I would change it up tonight," and further stated, "We can discuss in camera." Councillor Brand further alleged that Mayor Robinson subsequently advised that the established seating practices were to be respected and that any proposed changes were to be addressed through prior communications and mutual agreement. Despite this direction, Councillor Eby continued to occupy the seat, which she believed to be intentional rather than inadvertent conduct. Councillor Brand further alleged that on October 6, 2025, Councillor Eby again occupied her customary seat despite prior direction provided by Mayor Robinson. She alleged that when the issue was raised, Councillor Eby stated that the matter could be discussed in closed session. Councillor Brand alleged that Mayor Robinson reiterated her earlier direction, following which Councillor Eby departed the meeting and did not return. Councillor Eby was interviewed on these allegations. He indicated that when he joined council, it was shortly after the resolution of the previous Integrity Commissioner complaints, which were resolved around December 2024. As he began to attend meetings, there were obvious issues and tensions among elected officials and senior staff at the municipality. He became concerned about the repeated comments made by staff about a toxic work environment by elected officials and the liabilities from these issues. These comments were made repeatedly by one particular staff member and directed exclusively at Councillor Brand. He personally observed the tensions between Councillor Brand and the staff member, and it concerned him. Councillor Eby described the sitting arrangements at council table. Councillor Brand's seat was directly next to the staff members she was having conflict with. Councillor Eby explained that he took this seat to try and create a physical barrier between them and to hopefully force a resolution to the issues. Mayor Robinson intervened in what he was doing and asked Councillor Eby to raise issues in closed session with council. Mayor Robinson had become upset with him about this issue. He left one of the meetings to avoid the confrontation. As meetings progressed, he stopped doing this as it was not having any effect and the new complaint process had started. In all, he did this on 2 occasions. And the confrontation with Mayor Robinson was during the last event when he left the council chambers. With regards to the comments attributed to him about Councillor Brand being 90% negative, he denied saying this in any context. Analysis. Councillor Brand alleged that Councillor Eby violated 2023-136 sections 3 sub 4 about communications with council. I've already read this previously. Councillor Brand's evidence was that Councillor Eby said to her to the effect that if she continued to have a negative attitude while at the council table, she should reconsider her role in council. The second allegation was that Councillor Eby occupied Councillor Brand's regular seat at the council table. We find the allegation that Councillor Eby sat at Councillor Brand's seat to be a trivial complaint, and the Code of Conduct does not have specific wording on these allegations. Moreover, the head of council is responsible for enforcing decorum at the council meeting, including mediating this situation. Additionally, Councillor Eby actions were not for any malicious or nefarious reason. It was and does not meet the test of a violation of the Code of Conduct. To be clear, we find that Councillor Eby's account that his actions were an attempt to intervene when he saw as a negative conduct directed at a staff member of the municipality of Councillor Brand and not as a slight to Councillor Brand. Councillor Eby has denied using the phrase 10% positive, 90% negative in reference to Councillor Brand. As explained in the credibility assessment for Councillor Brand and Councillor Eby, the investigator does not accept Councillor Brand's evidence as she's been found to lack credibility. Councillor Eby has been found to be credible and his uncorroborated evidence can be relied upon. In other words, we accept Councillor Eby's version of events, including his denial that this one did not occur. Finding. The allegation that Councillor Eby breached bylaw 2023-1336 by occupying Councillor Brand's seat and saying that if she was going to be 10% positive, 90% negative, she should reconsider her role in council is unsubstantiated. Allegations against Councillor Gordon Muir. Allegation number 1. Question of Councillor Brand's integrity. This occurred between August 13th and September 2nd, 2025. It is alleged that Councillor Muir stated to Councillor Brand that it was her integrity that should be questioned. This stems from Councillor Muir when he was acting as deputy mayor and overseeing the closed session of council. It was alleged that the CEO had made various statements that Councillor Brand was calling him a liar. Councillor Brand specifically alleged Councillor Muir then addressed me stating that the matter was concluded and that my request for information was calling the CAO's integrity into question. He further stated that the only integrity that should be questioned was mine. In support of this allegation, Councillor Brand provided information related to the events that occurred between August 13th and September 2nd, 2025. She stated the matter arose in context of discussions regarding a draft R-zone policy during which the CAO had reportedly indicated that both the Ombudsman and legal counsel had approved the document. Councillor Brand sought to review the supporting documentation confirming these approvals, initially requesting the information directly from the CEO in person and subsequently by email, and no materials were provided. Councillor Brand further stated that she independently contacted the Ombudsman's office and was advised to obtain the information from the municipality. She indicated that after not receiving a response from the CEO, she proceeded to submit a formal request under the Municipal Freedom of Information and Protection of Privacy Act as a member of the public. The request was reportedly denied by the CAO, necessitating an appeal. Councillor Brand maintained that her inquiries were made to verify the accuracy of the statements regarding the external approval of the R-zone policy. She also questioned if legal counsel was actually involved. Councillor Muir was interviewed on this allegation. He indicated that Councillor Brand engaged in a repeated question of the CEO, including raising concerns about whether or not the policy had been reviewed or approved by legal counsel and external bodies, and Councillor Brand advised that she had 32 questions on the R-zone policy. Councillor Muir described these inquiries as part of a broader pattern in which Councillor Brand frequently challenged the CAO's work, including submitting numerous detailed questions and scrutinizing the contents of policies. He characterized his conduct as excessive and suggested that it placed an undue demand on administrative staff and reflected a lack of confidence in the CAO's work. With respect to the R-zone policy specifically, Councillor Muir stated that Councillor Brand questioned whether legal counsel would review the policy and raised multiple detailed concerns about its content. He indicated these actions contributed to a perception that the CAO's credibility and integrity were being challenged through repeated requests for verification and clarification. Additionally, Councillor Muir acknowledged that he questioned Councillor Brand's integrity during the discussion related to the R-zone policy and the conduct of the council meetings. He stated that after repeated questionings of the Chief Administrative Officer, he told Councillor Brand, "Enough is enough. Stop questioning his integrity," and further stated, "I'm questioning your integrity as of right now as to why you keep asking him the same question over and over." He indicated these remarks were made in response to what he perceived as repeated and unjustified challenges to the CAO statements and he described his comments as direct rather than intended to be disrespectful. Councillor Muir reported that in his view, this pattern of conduct was consistent with ongoing conflict between Councillor Brand and senior staff, particularly the CEO, and formed part of a broader history of these issues. He did not deny making the comment to Councillor Brand. However, it was in the context of her repeatedly questioning the CEO's credibility, her conduct regarding the R-zone policy, and his attempt to stop Councillor Brand's conduct directed at staff. Analysis. Based on credibility issues with Councillor Brand, the investigator does not accept her narrative of events. Councillor Muir was found to be credible, and his evidence is accepted. It is clear from the evidence that Councillor Muir said to Councillor Brand that it was her integrity that ought to be called into question, and his intent was to protect staff from misconduct. It is equally clear from the evidence that this is what Councillor Brand was doing with the CEO, although not using the exact phrase as Councillor Muir did. Bylaw 2023-1336, which contains the code of conduct for elected officials. 4D, councillors do not comment on another members or staff in a manner which casts aspersions on their professional competence or credibility. Councillor Muir was not casting doubts on Councillor Brand's professional competence or her credibility. His statement was about her integrity. Essentially, he was challenging her on questioning the CAO's integrity and attempting to stop the conduct directed at the CAO. The statement by Councillor Muir was a one-time event made under a very specific circumstance. On its own, given the ongoing context between the parties, this comment does not amount to a breach of the code of conduct. The allegation that Councillor Muir breached Bylaw 2023-1336 by saying to Councillor Brand that it was her integrity that ought to be called into question is unsubstantiated. Additional comments. During our inquiry, it was noted that there was a recurring issue with Councillor Brand's communications to staff or individual members of council being brought to the attention of council as a whole for response or action. Although Councillor Brand complained about this, there's nothing wrong with this practice. Staff do not take direction from individual councillors. In this particular context of the R-zone policy, the CEO brought Councillor Brand's request for information to council's table. It is for council to give direction, or not at their discretion if there should be a response to Councillor Brand. Given the history of these matters, it is understandable as to why council has chosen this process. As for filing the MFIPA request, it is Councillor Brand's right to do this. It is not a matter for the Integrity Commissioner to consider. November 27, 2025. During the meeting of council of November 27, 2025, there was a discussions relating to employee number 2. Prior to these discussions, it was alleged that Councillor Muir asked Councillor Brand if she was going to declare a conflict of interest. She indicated that she would not. Councillor Muir's question was in relation to the historical OHSA findings against Councillor Brand in relation to employee number 2. At the conclusion of the meeting, it is alleged that Councillor Muir advised the other members of council to write down what had been said during the meeting in case it shows up on social media. Councillor Brand alleged that this insinuated that she would breach the confidentiality of the closed session of council. It is also alleged that Councillor Muir accused Councillor Brand of sharing closed session information about the water logs for the municipality. This issue is not fully explained in this report, however, it relates to testing logs for that the municipality maintains as part of its clean water responsibilities. Councillor Brand stated that Councillor Muir asked if she was going to declare a conflict of interest in relation to matters involving employee number 2. She indicated that while she had declared a conflict of interest with respect to matters involving her family member, Councillor Muir asserted that she was also required to declare an additional item connected with employee number 2. She maintained that she did not understand why this was necessary and emphasized that she is supposed to declare her own conflict of interest. Councillor Brand further stated that Councillor Muir made comments that suggested she could not be trusted to maintain confidentiality of closed session discussions. She indicated that at the conclusion of the council meeting, Councillor Muir directed members to document the discussion in case it showed up in social media later, which interpreted as an insinuation that she would disclose the confidential information. In addition, Councillor Brand stated that Councillor Muir asserted or implied that she had breached confidentiality in relation to the water logs matter. She indicated that Councillor Muir alleged that a social media post was verbatim to the comments made during a closed session, thereby suggesting that she had disclosed the in-camera information. She denied sharing such information and maintained that her knowledge of the issue was either publicly known or independently obtained. Councillor Brand characterized these instances as reflecting a pattern of conduct by Councillor Muir that, in her view, questioned her integrity, challenged her judgment, and respected a conflict of interest, and imply that she cannot be relied upon to maintain confidentiality of council proceedings. Councillor Muir stated that his instructions to council members to document the discussions was not directed to Councillor Brand specifically, but was intended as a general precaution. He said that he told council, going forward, make sure you write down what you're discussing in case anything comes out of chambers, and that the comment was directed to everyone. With respect to the water logs matter, Councillor Muir stated that confidential information discussed in closed session appears subsequently on social media associated with Councillor Brand's family member. He indicated that based on timing and content, somebody in that room, being council, had leaked that information, and it magically showed up on Councillor Brand family member's social media. While he did not identify a specific individual responsible, he maintained that the appearance of the information outside of council supported concerns that confidentiality had been breached. Councillor Muir characterized his actions as intended to maintain order, protect the integrity of council's proceedings, and address what he viewed as an ongoing issues affecting the effective governance. He stated that his comments and interventions were made in a context of managing council process, addressing perceived ethical concerns, and ensuring that discussions could proceed openly and appropriately within council. Based on the evidence before us in the matter, council did discuss this issue. And almost immediately after the closed session, the social media post was made by Councillor Brand's family member. The investigator shares Councillor Muir's concerns that this information was leaked from a closed session of council. Analysis. Councillor Brand has been found to be not credible, and her uncorroborated evidence is not accepted. Councillor Muir has been found to be credible. Where there's a conflict in the evidence between the two members, the evidence of Councillor Muir is accepted. In summary, we accept Councillor Muir's narrative for this particular allegation and not Councillor Brand's. The allegation is that Councillor Muir made the above comments breach sections 4D bylaw 2023-133-6. Councillor will not comment on another member staff's manner, which casts aspersions on provincial competence or credibility. Regarding the comments made by Councillor Muir to Councillor Brand, whether Councillor Brand should have declared a conflict of interest in matters before council related to employee number 2, is not a contravention of the Code of Conduct. His query was made from concern about the conduct of Councillor Brand towards employee number 2, and not an attempt to undermine or otherwise make a comment on her professional competence or credibility. Of import in the circumstance is that due to the natural history of these matters, and specifically previous findings against Councillor Brand and related to employee number 1 and 2, Councillor Brand being involved in anything involving the staff members' employment is of council's concern generally, since they are obligated on the OHSA to take all reasonable precautions to ensure that the workplace is free from workplace hazards, including workplace harassment. The Code of Conduct requires members to comply with the law and municipal policy. Councillor Muir's query is justified in this situation only. In the normal circumstances, the responsibility of the member to declare that they have an interest in a matter in accordance with the MCIA and act accordingly, not for another member to provide advice or guidance or comment on another's interest in the matter. This allegation was not considered as an allegation against Councillor Brand. To be clear, we did not consider whether Councillor Brand was required to declare an interest in the matter before council. Equally, Councillor Muir had good reason to be concerned that someone had leaked information from the closed session of council about the water logs. His explanation that suggested that those in attendance make good notes and brought this issue to everyone's attention was reasonable. Every member has the obligation to enforce the procedural bylaws as well as the Code of Conduct and may remind others of their obligation under these and other municipal laws or policies. Councillor Brand believed it was an attack on her personally, however, it was not. Based on the balance of probabilities, we find the allegations that Councillor Muir breached bylaw 2023-1336 when he allegedly disparaged Councillor Brand by requesting her participation in the matter involving employee number 2 and the leaked water logs is unsubstantiated. Allegations against Councillor Brand are grouped into 2 categories. The first series of allegations concern her conduct involving employee number 1 and employee number 2 and their family. The allegations can be generally summarized as follows. Councillor Brand engaged in a series of actions that harass these employees and their family, thereby breaching both bylaw 2023-1336 and the Occupational Health and Safety Act. Although governed by 2 separate laws, the facts of the harassment are the same. The second group of allegations relate to breaches of confidentiality. Allegations of harassment. The OHSA has specific language that protects the information from public disclosure. These allegations are also part of the initial Integrity Commissioner complaint that started all of the processes being reported. The following is a concise summary of the allegations and findings from the OHSA investigation. The aspects that are within the public domain have been included in the summary. However, there are other events that cannot be disclosed in this report. Councillor Brand's family member has been engaged in a long-term harassment of the employees in question and their family. This harassment was in person and extensive on social media. This culminated in Councillor Brand's family member being charged criminally with harassment and other related charges. As part of their bail release, the family member was prohibited from being in proximity to the employees and their family, which meant they could no longer live across the street from them. The conduct of Councillor Brand's family member led to the employees to sell their home in the Red Rock and leave the community. Around November 7th to 11th, 2026, Councillor Brand's family member posted a request on Facebook for people to send them evidence that the employee and their family member had moved from the residence in Red Rock. They wanted this information in order to get a bail variance to move back home. Members of the public observed Councillor Brand in her vehicle parked outside the employee's residence on various occasions. They recorded this on their home security on 2 occasions. Employee number 1 also recorded this herself on 1 occasion. One member of the public who was also subjected to the harassment by Councillor Brand's family member filed an Integrity Commissioner complaint against Councillor Brand and notified employee number 1 of their observations. This in turn led employee number 1 to filing her own complaints against Councillor Brand. Councillor Brand admitted to parking out front of employee number 1's and 2's residence on 8 occasions over the course of 4 days during the time frame of November 7 to 11, 2025. She also asserted that employee number 1 and her family had moved from the residence in August of 2025. Councillor Brand's reason for parking out front of the residence was in response to her family member's request for evidence that employee number 1 and her family had moved, and to see if council would file a complaint against her for doing this. Councillor Brand also denied taking any photographs or videos of employee number 1's residence. She did explain that she may have had her phone up over the steering wheel in a similar action, but she may have been talking to someone on the phone. Councillor Brand also submitted to the investigator a photograph she had taken on November 7th, 2025 of employee number 2's truck attached to a U-Haul trailer parked out front of the residence. She explained that she had taken this photograph as the truck was obscuring view of the intersection next to the residence. She also asserted that employee number 1 and her family had moved from the residence in August 2025. On November 7, 2025, employee number 1 and family members saw Councillor Brand taking a photograph or a video of the residence and took a video of her as she was walking away. This was while they were actively inside packing up the residence. The photograph submitted by Councillor Brand appears to be her taking the photograph while being videotaped by employee number 1. The evidence from a variety of witnesses indicated that employee number 1 and her family lived on and off in the residence until mid-December of 2025. They had not moved in August 2025 as submitted by Councillor Brand. The investigator has serious concerns over the veracity of the evidence provided by Councillor Brand in these events. The findings from the events relating to Councillor Brand parking out front of employee number 1's residence were as follows. Around November 7th to 11th, 2025, Councillor Brand parked out front of employee number 1's residence. This occurred at least 8 times. On various occasions, she used her mobile phone to take photographs or videos of the residence. Councillor Brand did this in the context of the criminal harassment related charges that her family member was facing before the courts. The purpose was to prove whether employee number 1 and her family had moved from the residence. Councillor Brand took the pictures of employee number 2's U-Haul to support her family member's request for evidence that employee number 1 and her family had moved from the residence. Councillor Brand was at minimum reckless as to whether or not her conduct would harass the employee's family and was engaged in conduct at the very least. At very least, that exasperated the harassing conduct by her family member directed at employee number 1 and her family. The investigator rejects Councillor Brand's assertion that she did this to see if the municipality would complain about her conduct for doing this. This explanation is nonsensical given the evidence in the matter. Based on the balance of probabilities, the allegation that Councillor Brand parked out front of employees number 1's residence is substantiated, and it was done in the context of an ongoing harassment of employee number 1 and her family by Councillor Brand and her family member. The remaining allegations and the evidence uncovered during the investigation are protected by the OHSA. As part of the OHSA investigation, several people were interviewed. These included elected officials, employees of the municipality, and Councillor Brand. The investigator attempted to interview Councillor Brand's family member and employee number 2 as part of the OHSA and the Integrity Commissioner investigations. However, they declined to participate in the investigation. In all, there were 4 allegations made against Councillor Brand. These were 3 were substantiated. Only the one above can be reported in this form due to the restrictions in the OHSA. Ultimately, the findings in the OHSA investigation were that Councillor Brand breached both bylaw 1336 and the OHSA provisions relating to workplace harassment and her conduct directed at employee number 1 and her family. The conduct by Councillor Brand in the OHSA matter was found to be very serious. It had a significant and detrimental impact on the employees and their families' well-being. The following were the mitigating and aggravating factors in the OHSA report and the closing remarks by the investigator. Mitigating factor. The investigator has not identified any mitigating factors for consideration in this matter. Aggravating factors. The harassment was protracted and had a very serious backdrop. One of these historical issues is the harassment, the criminal charges, and her against her, and that Councillor Brand was participating in these events through her actions in November 2025. Councillor Brand has been previously found to have harassed in the workplace. When these new events occurred, the employer had already had various protective measures in place meant to mitigate the impact and safety concerns. These measures did not prevent a recurrence of the harassing behavior by Councillor Brand. Councillor Brand appears to lack the insight into the impact of her conduct and the impact on and her family. Councillor Brand provided false and misleading evidence during the investigation. The investigator's opinion that Councillor Brand's conduct directed at employee number 1 was very serious and had a significant negative impact on employee number 1 and her family. Based on the history of this matter, it is unlikely that Councillor Brand will take meaningful steps on her own to curb her conduct in the long term. Analysis. The allegation is that Councillor Brand breached bylaw 2023-1336. The relevant section is number 9, not to engage in harassment. Harassment shall mean any engaging in a course of vexatious comment or conduct that is known or reasonably known to be unwelcome. The definition is essentially the same as the OHSA for harassment. Finding. Based on the balance of probabilities, the investigator finds the allegations that Councillor Brand repeatedly breached bylaw 2023-1336 and the OHSA by harassing employee number 1 and their family is substantiated. This occurred between January 2025 and January 2026. Allegations of breach of confidentiality. There are 2 separate allegations that Councillor Brand breached confidentiality in disclosing information that she learned in her role as a council for Red Rock. Note, there was a 3rd allegation involving the disclosure of the water logs that is referenced elsewhere in this report. It has not been analyzed and reported here as it predates the December 2024 cutoff date for complaints to the Integrity Commissioner. Hiring process for the new CAO. From late 2025 to early 2026, Council for Red Rock was engaged in the hiring process for a new CAO. There was a hiring committee created. Ultimately, the matter was brought back to Council for consideration. There were some discussions with Council and some disagreements on the process being followed. Councillor Brand was part of emails going back and forth on the hiring process for the new CAO. She was the only one who raised a particular provision that she wanted to see in the new CAO's contract. The exact nature of this provision is not included in the report, as it is a private employment matter, and the disclosure is not necessary for the purposes of this report. On December 21st, 2025, Councillor Brand sent a lengthy email to Council. Quote, in preparation for the upcoming CAO interview, I'm requesting certain information I would believe would be beneficial to support a well-informed and transparent interview process. Specifically, I'm requesting. Councillor Brand then listed a number of items such as pay scales, holiday entitlements, and so on. Councillor Brand then stated, finally, I have consulted with an HR department and they advised that a requirement may be included if the employment contract contains a clause. I would therefore like request that such a clause be included in the CAO's contract. It is not already. They advise that during the interview process, it is appropriate to ask candidates questions regarding, for example, this would help assess the candidate's flexibility, commitment, and understanding in the needs of our community. On December 2025, Mayor Robinson replied to Councillor Brand's email. In part, she raised concerns about the apparent breach of confidentiality by Councillor Brand for speaking to an outside HR department about the hiring process for the CAO without express direction or authority of council. She stated, Council considered recruitment in closed session under the Municipal Act. Council then established a hiring committee approved by Council at the November 27th open session meeting. Concerns have arisen now that the individual councillor independently sought information from a third party relating to the hiring practice while the recruitment process is ongoing. Councillor Brand replied to the mayor on December 23, 2025. I appreciate your comment regarding my previous email and concerns about the potential breach of code. I have since sought advice and have been informed that it would only constitute a breach if I had included individuals who were not part of the closed session. Councillor Brand was interviewed on this allegation. Her evidence was that during the hiring process to select the new CEO, she wanted a certain clause added to the contract. She was told by council that they could not put that clause in the contract. They kept saying no, that it could not be done. For this reason, she went to see an HR department and was told yes, such a clause could be included in the contract. She was also told by the HR person that they could also ask questions of the candidate on this issue during the hiring process. Councillor Brand advised it was a quick conversation with the HR member. At this point in the interview, Mr. Judson submitted that he did not think it was wrong for Councillor Brand to seek outside information about a very general question, as she would not need to reveal anything confidential. Councillor Brand was asked to identify the person she spoke to and to provide contact details for us to validate the information she was providing. Councillor Brand provided the HR person worked in the same workplace as her. Councillor Brand could only remember the person's first name and undertook to get the person's last name and contact information. She would then communicate it back through to the investigator through Mr. Judson. On June 9th, 2026, Mr. Judson provided the following on behalf of Councillor Brand. The investigator has redacted the details that identified Councillor Brand's employer. Councillor Brand has spoken with at her place of employment. This person does not recall the earlier discussion she had with Councillor Brand. The person, if the integrity commissioner wished to make inquiries, though we would expect that these are done sensitively, as this is Councillor Brand's employer we're talking about. We do not want to raise further concerns that this line of inquiry is beginning to lack jurisdictional foundation, as the complainant has provided no particulars of any confidential information that was shared with a third party. This strikes as somewhat of a fishing expedition based on a bare and unparticularized complaint. On June 17, 2026, the investigator interviewed the HR member who works with Councillor Brand. She advised that she is an HR professional and works at the managerial level of the organization and confirmed that Councillor Brand works in the same workplace. She was asked if she ever had a conversation with Councillor Brand about the specific clause for the employment contract. These are the specific questions from the interview. Question: have you ever had a conversation with Cindy, Councillor Brand, about the ability to put in someone's contract this clause? Have you ever had that conversation with her? No, I haven't. That would not be something I could advise on anyways, like I wouldn't feel comfortable talking about that. So it's not like you don't remember it happening or not. It didn't happen, question mark? It didn't happen, no. The HR member went on to explain that recently Councillor Brand booked a meeting with her and attended her office. On entering the meeting, Councillor Brand said to her, "You weren't the one I was talking to," and this is the end of the meeting. It appeared that she was not the one Councillor Brand was looking for and did not provide any context as to what this meeting was about. The HR member went on to explain that she canvassed with other members of her team and no one remembered this conversation with Councillor Brand. There have been some members who left the team that she did not speak with. She advised that there was a team member with the same first name who left the organization in December 2025. In closing her interview, the HR member stated, quote, "I'm surprised that she knew it wasn't me and she would give you my name," end of quote. Information to pertain to Councillor Brand's family member. Council for Red Rock took measures in 2023 to manage the impact of Councillor Brand's family members' conduct on staff and elected officials for the municipality. The measures included issuing this individual with a trespass notice. Although this matter was discussed as part of a closed session deliberations, it is included in the report as it is necessary to understand the context of the allegations. Also, the individual subject of the trespass order has repeatedly referenced it themselves in social media posts. This was an internal confidential document for the municipality and Councillor Brand's family member. It was not meant to be shared publicly. The trespass order was issued on October 16, 2023, and signed by the previous CAO, Mark Figliomini. The investigator has reviewed 21 separate notices filed by Councillor Brand where she declared a pecuniary interest in the matters involving this trespass order. She used the word trespass order and indicated it involved her family member in several of the declarations. The first time she used the name of her family member in the trespass notice was on February 5th, 2024. All the notices that Councillor Brand filed from January 16th, 2026, and all the notices were filed between January 16th, 2023 and November 17th, 2025. The investigator also reviewed minutes of council and notes made by the clerk and confirmed the matter was discussed in closed session multiple times starting in 2022. The investigator has been provided with a very extensive social media posts made by Councillor Brand's family member. These were collected on an ongoing basis by the municipality from 2022 into 2024. The investigator has been provided with additional posts that go in as late as June of 2026. In all, there are dozens of unique posts that have been viewed by the investigator. It is apparent from the social media post by Councillor Brand's family member that they believe that the CEO, Mark Figliomini, was responsible for issuing the trespass order. This is consistent as it was him who signed it. In all the posts viewed by the investigator, Councillor Brand's family member referenced the trespass notice on 6 occasions. I'm not going to read them all. They're all there on the screen. Bottom of the page. On June 15, 2026, the investigator interviewed Councillor Eby regarding the allegations against him. During the course of this interview, he disclosed that Councillor Brand had discussed the trespassing of her family member with him. At the time they met, Councillor Eby had not been appointed to council. He was a member of the public and was considering applying for appointment to a vacant seat. Councillor Eby advised that during the meeting, Councillor Brand alleged that there had been a theft or misappropriation of a large sum from the municipality by a staff member at the municipality and 2 elected officials, and that she was concerned about their integrity. Note, the names she listed to Councillor Eby are not included in the report as there is no basis for the claims by Councillor Brand, and the names are not germane to our inquiry finding with respect to the allegations. Next bullet point, Councillor Brand advised that she was the only elected official who had the interests of the community members as a priority. In the quote, she spoke about how the CEO, the mayor, and councillors were wrong to issue a trespass order against Councillor Brand's family member. These statements made by Councillor Brand unsettled Councillor Eby as they were not public knowledge. Councillor Eby had written on a calendar the date of the conversation, and it occurred on January 26, 2025. Councillor Eby explained that Councillor Brand informed him that the township had this trespass order against her family member, and that she felt it was wrong and should not have happened. She stated, "How could the township put a trespass order against a citizen? It's just so wrong." Councillor Brand was asked to comment on this allegation. She did not reply directly to the investigator. Mr. Judson provided a response on her behalf. In an email exchange with the investigator, Mr. Judson refused to address the allegations. The investigator to Mr. Judson. The allegation is very straightforward. Did Councillor Brand discuss the fact that her family member was trespassed from the municipal property or not with Councillor Eby before he was elected to council? If your assertion is that she received this information from somewhere else, then council, I'll need to know the source of that information. End of quote. The following was the final submission to the investigator. We aren't engaging in this witch hunt. It is the complainant's responsibility to make specific complaints to you about what confidential information was improperly shared for you to provide that complaint to the counselor with particulars so she can make full answer and respond to it. Instead, you're being vague and imprecise in the scope of your inquiry. It is not appropriate for this inquiry to be a moving target with trick questions and last-minute expansions of scope. Moreover, Councillor Brand has absolutely no obligation to provide you with a window into every private conversation she may or may not have, or what source of her knowledge of non-confidential information might be. You are denying her procedural fairness by not actually providing her with copies of the complaints that were made with specific particulars. We encourage you to rely on the provisions of the Municipal Act, which allow you to seek legal advice in regards to the township's expenses or your advice to Councillor Brand or our advice to Councillor Brand would be seek judicial review of any findings made against her based on the flawed and improper process. In short, it is not Councillor Brand's onus to prove her innocence to you. Analysis. Bylaw 2023-136 Code of Conduct for Elected Officials speaks about confidentiality. I've already read this in regards to Mayor Robinson. Consulting with HR. The evidence that Councillor Brand breached confidentiality comes from her own email, where she states that she consulted with an HR person about a specific language for the new CAO contract. When confronted with the possibility of having breached confidentiality, Councillor Brand did not directly address the allegation, but instead provided that it would only constitute a breach had I included individuals who were not part of the closed session. In her submission to the investigator, Councillor Brand indicated that the HR person was from her own workplace, and she did not provide her with any confidential information. Councillor Brand was asked to identify the HR person in order for them to be interviewed. Mr. Judson later provided the name of the person to be interviewed. In his correspondence, Mr. Judson stated, Councillor Brand has spoken with at her workplace of employment. This person does not recall the earlier discussion she had with Councillor Brand. The evidence from the HR professional was not that she does not recall the discussion. The fact is the conversation never happened. Based on this and Councillor Brand's credibility in general, the evidence left for the investigator to consider is the actual email from Councillor Brand to Council. In the email, Councillor Brand stated, I have consulted with an HR department and they advised that a redacted requirement may be included if the employment contract contains a clause. They also advised that during the interview process, it is appropriate to ask candidates questions regarding, are you willing for this role? On plain reading of Councillor Brand's email, she spoke to a person outside of council about the new CAO employment contract concerning provisions that could be included in the contract and about specific interview questions that to be asked of the candidate. The fact that she was submitting to council for consideration that she wanted this particular clause added to the CAO's employment contract was confidential information, let alone that they were in the midst of interviewing candidates. Her discussions of this clause and the specific interview questions in support of this working condition breached the confidentiality of council. Trespass order. The evidence from Councillor Eby is that he received specific information from Councillor Brand about her family member being trespassed from the municipality. At the time, he was not a member of council and was not entitled to the information she was providing. Part of the information provided was that it was the CAO, mayor, and council who issued the order. The evidence also demonstrated that this issue was before council numerous times as early as 2022 until today. The social media posts seen by the investigator did not include the level of information that Councillor Brand provided to Councillor Eby. There is also no clear source of information that Councillor Brand shared other than the information that she learned in her role as an elected official. Finding, based on the balance of probabilities, the allegation that Councillor Brand violated bylaw 2023-1336 by disclosing confidential information to Councillor Eby about the family member's trespass order is substantiated. The same is substantiated in regards to the CAO hiring process. Conclusion and recommendations. The Integrity Commission, upon finding a member has contravened the Code of Conduct, may make recommendations on penalty. We make the following recommendations. And just to council, Mr. Pappas gave you a very good overview on how this imposing different penalties are. Take some of these are recommendations and some of these are out of the act. So I would I'd very much take Mr. Pappas's direction on this. Finding against Mayor Robinson. Mayor Robinson was found to have communicated information about the Integrity Commission inquiry to a third party who is also a potential witness in the inquiry. We recommend that Mayor Robinson receive a reprimand. Finding against Councillor Brand. Councillor Brand was found to have made serious contraventions of the Code of Conduct and the OHSA. We recommend that Council request Councillor Brand to resign from her position. If Councillor Brand refuses to resign, we recommend the following. Councillor Brand's remuneration be suspended for a period of 90 days. Should be removed from all local boards and committees. There should be served a trespass notice for all municipal properties. That should only be allowed to attend council meetings electronically. The council report her breaches to the Ministry of Labor and seek direction on how they can ensure a workplace free from harassment. The following, the final appendix, Your Worship, is the credibility assessment. I don't propose reading that in. It's available. I've referenced it a number of times throughout the report. I'm available for any questions or comments that you may have at this time.
Thank you for that report. As I advised council earlier, we are just receiving the report. All right. Okay. I'd like to thank you for all the work that you've done. It's been a long 7 months, but this is the document that you've produced, and we will move forward with the deliberation and reprimand portion of the meeting. So thank you.
Thank you. I'll be available in the background if you have any questions, but subject to that, thank you very much. And I'd just like to thank the CAO and her staff. They're very helpful through this, and council generally was very supportive. So thank you again for your time.
Thank you very much. Okay, be resolved that council receive the Integrity Commissioner report on the Code of Conduct investigation as information. I have a mover and seconder. Councillor Smith, Councillor Evie, all in favor? Motion is carried. Okay, I'm now going to pass the chair over to Council or Deputy Mayor.
Right. So I'll call a motion to consider and discuss the recommendations provided in the Integrity Commissioner's report on the Code of Conduct investigation, and that council deliberates the decisions on penalties, if any. Can I get a mover and seconder? Moved by Mayor Robinson, seconded by Councillor Smith. Floor is open, council.
I would like to make a statement, please.
Mayor Robinson.
Okay, I appreciate the thorough and independent review conducted by the Integrity Commissioner. While I accept the findings regarding my disclosure, I will ensure greater care in the future. I will accept council's decision of my reprimand, and I will accept a recommendation to resign if asked. The integrity of the council and my role as mayor is paramount in moving this community forward. It will continue to cost taxpayers money if people aren't held accountable for their actions. I am pleased that the remaining allegations against me were found to be unsubstantiated and basically fabricated. Throughout this process, my priority has always been to protect township staff, uphold my responsibilities as mayor, and serve the residents of Red Rock with integrity and professionalism. Thank you.
Thank you, Mayor Robinson. Floor is open. Councillor Brand.
While I disagree with the findings in this report and the basis upon which they were made, I respect the Integrity Commissioner is empowered to reach conclusions based on the investigation, and it is council's role to decide how to respond to the report in accordance with the municipal. My lawyer has written to council and the CAO, and I will rely on his letter in response to the report and setting out the proper role of council tonight. I reserve my right to challenge the findings in the report or council's decision should it make an unlawful decision. I will make no further comment and will review council's decision from today with the assistance of my lawyer. Thank you.
Council, we'll discuss Mayor Robinson's first. I'll open the floor for Mayor Robinson's recommendations. Councillor Smith.
First, thank you, Sean, for the report. It was informative. I believe he did a very thorough investigation. I don't disagree with the findings in regards to Mayor Robinson. I do believe we should do a reprimand as it was found. But one thing I do state as well is that what is appreciative is the forthcoming and the honesty in her responses that are shown in the report. So as well as her statement. So I do agree that a reprimand should be in place. As to what that reprimand is, I am still deciding.
Councillor Evie.
I appreciate the candor with which Mayor Robinson shared with the investigator and her cooperation with the process. And it is in the context of extreme distress that you and your family were experiencing that I think contributes to consideration of what's an appropriate consequence. So I would be in agreement with the written reprimand. Thank you.
Okay, council, I agree as well with coming forward with the evidence. I agree a reprimand is needed as well. So I'm putting a motion on the table to reprimand Councillor Robinson with just the reprimand. I have a mover and seconder. Written reprimand. May I have a mover and seconder? Moved by Councillor Smith, seconded by Councillor Eby. All in favor? Motion is carried. Thank you, Mayor Robinson. Okay, Council, I'm going to open the floor up now. Councillor Brand.
I'd like to speak.
Mayor Robinson.
Okay, the Integrity Commissioner's report makes one point abundantly clear. Allegations must be supported by evidence. 2 of the most serious complaints against me were found to be without merit with a thorough review of the facts. One allegation accused me of sending derogatory correspondence, yet the investigator determined that the complainant had never seen the emails and that the actual correspondence was professional, factual, and appropriate. I wish my full email was present, at least for display in this report tonight, so you can see better context of what was written and sent. The second alleged that I participated in a matter of closed session despite declaring a conflict of interest. But the official minutes, the clerk's notes, and the documentary evidence confirmed the item was never discussed because there was no quorum. Basic, no quorum, no discussion. I respect the Integrity Commissioner's process and findings. Public officials have the responsibility to ensure serious allegations are based on verifiable facts and not unfounded accusations. The Municipal Act only allows 2 actions of reprimand. I don't believe that's enough, but those are the only options we have. I believe Councillor Brand should receive a written reprimand and suspension of remuneration for 90 days. And if possible, I do ask Councillor Brand what she thinks of the recommendations provided in the report and if she feels if any of them are warranted.
I'll start off as well too on that. I agree with the remuneration and the maximum penalty as well due to the evidence that was provided. Open the floor, Councillor Smith.
Again, I appreciate the thoroughness of the report. What I kind of look at when I'm thinking about penalties or remuneration or reprimands is again, very much truthfulness and honesty in what was found in the report. Everything in there was a lot of, or I won't say a lot, there was a number of instances of misleading information provided or failure just to provide some information. But so with that, there were substantiated findings. I can only go with those. I do agree with the written reprimand and the 90 days of suspension of remuneration.
Councillor Eby.
So we have problematic behaviors have been alleged and verified by the Integrity Commission. And so the considerations before us today are, we need to uphold the integrity and values of our community, and we must protect the financial sustainability of our township. Ignoring these behaviors is the same as approving them, so there needs to be prompt measured consequences. A letter was received from Douglas Judson, lawyer for Cindy Brand. He stated that he may, at Cindy Brand's direction, seek litigation against the township and seek legal costs. Mr. Judson stated that he may, at Cindy Brand's direction, file for a judicial review of the Integrity Commissioner's report and any actions of this council. These overt threats are a concern. They both pose a financial vulnerability and a threat to our township, a direct financial threat. Our budget is limited and primarily based upon taxes paid by residents and a handful of businesses, along with sporadic government grants. We are determined to grow and prosper as a community. These financial hits would be hurtful to our goals. So what to do? I reflected upon my family history and grandparents and parents moving here and sister moving here, but I'm not going to bore you with that. But I reflected upon it because what we share and what we do isn't just about us today. It's about who we choose to be as individuals, as family, as a community. And the choices we make will reflect in the lives of our children and grandchildren. We're faced with real problems, and I hope we can resist the urge to become us versus them. I pray that we don't choose to ignore uncomfortable truths because of friendships or family relationships. It's my belief that we'd be better served to engage with each other directly, honestly, and with the shared goal of learning from this and making things better going forward. An election is upcoming. We will together choose our next leaders. I trust that our community will make the right decision. So my position on consequences would be a suspension of the members' honorarium for 90 days. Thank you.
Thank you. We see no further comments. May I have a mover and seconder to accept the reprimand and the suspension for 90 days of pay? So this will be suspend remuneration for Councillor Brand for 90 days effective immediately, and one written reprimand for Councillor Brand. May I have a mover and seconder? Councillor Smith, Councillor Eby, all in favor? Motion is carried. This concludes this section of the meeting. I'll turn it back over to Mayor Robinson.
Be it resolved that the council direction is as follows. He just said, okay. Okay, so there's no closed session report. So confirming bylaw 2026-1449, resolution to confirm proceedings of council meeting. Could I have a mover and seconder? Councillor Eby, Councillor Brand, all in favor? Motion's carried. Thank you everyone for coming tonight. Our next meeting is August 12th, 6:30. Okay, thank you.